What is an evidence hearing in Arizona family court? If you've got a contested family law issue in Arizona, like parenting time, spousal support, or property division, you might be headed towards something called an evidence hearing. Well, what is it? How should you prepare? And what should you expect when you get there? Hi, I'm Bryan Shaw. I've been representing clients in Arizona family courts for over 12 years. If you've been scheduled for an evidence hearing, it likely means there's a disagreement that the court really needs to resolve. So let's walk through what that means and, of course, how to get ready. So, first, what is an evidence hearing? An evidence hearing is a formal court proceeding where both sides present testimony, documents, and exhibits to help the judge decide on unresolved issues in your case. It's not a casual meeting, it is a very structured legal process, and it could be your only chance to present certain facts and claims. So, what happens during that hearing? Each side will, of course, have the opportunity to testify, call witnesses, present documents such as photos, text, emails, or other records, cross examine the other side or their witnesses. The judge will listen and may ask questions, and eventually the judge will make a decision based on the evidence presented. Depending on the complexity of the case, a hearing might last a couple of hours or even span multiple days. Preparation is absolutely critical. If you want to gather and organize financial records, communication logs or emails, school medical records, if kids involved, any and all documents that support your position, that would be best. Your attorney will submit these as exhibits and may reference them when you testify. How should you act at a court evidence hearing? First impressions really do matter. Dress neatly and conservatively, arrive early, turn off your phone, be respectful to everyone in the courtroom. And when you're testifying, speak clearly and honestly. Stick to the facts. Don't argue with the other side and let your attorney guide the process. There are a few things to avoid. Avoid emotional outbursts or interrupting the judge or the opposing side. It can really kind of hurt your credibility. Also, avoid bringing in new evidence at the last minute. If it hasn't been properly disclosed, the judge just may not allow it. What happens after the hearing, though? The judge may issue a ruling right away from the bench or may take the matter under advisement and send a written decision at a later date. That ruling, of course, becomes part of your court order and can impact parenting time, child support payments, or the division of property. This is why legal representation matters. Evidence hearings are high stakes. You're presenting your case on the record, and it can shape the outcome of your divorce or your custody matter. Having an experienced attorney really helps. We'll guide you in your preparation of the case and help you avoid some common mistakes. If you've got an evidence hearing coming up in Arizona, we're here to help. At the Shaw Law Group, we'll guide you through the entire process with clarity, of course, strategy, and support. If this video was helpful, please check out some more of our free resources at bryanshawlaw.com or right here on the channel. Thank you for watching. We hope to hear from you soon.